I haven't ever heard of lawyers being summoned for the clients that they have advised. This is clearly a very, very shocking move that came from Enforcement Directorate. But that being said, the powers of ED were upheld by the Supreme Court itself. Were they within those powers or they crossed the line?
So the powers of the ED to summon a lawyer has not been upheld.
Okay.
So the Supreme Court is examining this issue, and today also this matter was listed before the Chief Justice. There is a very interesting balance which the court has to maintain. And the balance is that if you see the privilege that a lawyer has of not disclosing a privileged communication, whether it be an advice or whether whatever client tells him in the course of his engagement, there are two caveats to that. And the caveats are with regard to if the lawyer is involved in the crime itself in some form or the other. I'm just trying to simplify it for you.
Yeah.
So if the lawyer is involved in the crime, then that is not a privileged, then anymore a privileged communication. And the lawyer is bound to disclose. But the real question is that who decides or on what basis the enforcement agency or even the regular police, because the issue is not only of enforcement agency, the reference by the division bench of the Supreme Court is not on the Enforcement Directorate matter, but on a state police summoning a lawyer. Who will decide that the lawyer has actually crossed the line and done something himself? Which does not entitle him to claim privilege. So some balance has to be struck. And the balance has to be struck looking at the larger picture, which is that the regular or the indiscriminate or the summoning without any justification will have a chilling effect on the administration of justice.